Yeah. Okay.
Good morning. Probate court number 2 is now in session. Honorable Pamela Medina presiding.
Good morning.
Well, that's why we got the video on.
I don't have. I apologize. I will be
This
right.
is our camera here. You want to sit there or you want to sit here?
Whichever is easier for them to see me.
It doesn't matter. You see both.
No,
I'm worried about what's most comfortable for you.
no, this is fun.
Okay.
Sit on this a lot. There's you.
Mm-hmm. There's you
Where am I?
right there.
Oh,
Looks pretty yummy.
yeah, it's cold.
Morning. All right. I cause number
I don't hear any audio.
510785. Guardianship. I'm sorry. Probate of will with letters testamentary for Diamond K. Harrison. Mr. Wright, are you ready to proceed?
Good morning, Your Honor. This is Teresa Clark at Wright Abshire.
Morning. How are you?
Hard to hear them.
Fine, thank you.
I know it.
Welcome to the bench.
Thank you.
I'm testifying on behalf of my client, Arthur Harrison.
Okay, let me go ahead and at this time, what I'm going to do, Ms. Clark, is if everybody could please unmute. If you are going to testify today, if you could please unmute, raise your right hand so I can swear everyone in.
Hey, Joni, would you come in here so she can swear you in?
And unmute yourself and I will swear you in. And I'll ask the attorneys, if your witness isn't here, just let me know and I'll swear them in at the time of their hearing. Okay. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do. I do.
Thank you. Okay, Ms. Clark, you may proceed.
Thank you, Your Honor. I represent the applicant Arthur Harrison. And I
Well,
am
this is
familiar
great.
with the facts of this case. Diamond K. Harrison, also known as Diamond Kittipper Harrison, also known as Diamond Catherine Harrison, died less than 4 years ago on September 18th, 2022, at the age of 95 in Harris County, Texas. She was domiciled and had a fixed place of residence in Harris County on her date of death. She owned real and personal property with a probable value in excess of $10,000 on her date of death. The decedent's last will dated November 11th, 2008, the original of which had been filed with the court, was never revoked so far as I know. At this time, I would request that Your Honor take judicial notice that the purported document on file with this court is the original will offered for probate today.
Yes, the court takes judicial notice of the original will filed with the court. Thank you.
Thank you, Your Honor. Decedent was not married at the time of her death. She was married to William L. Harrison until his death on November 8th, 1984. No marriage was dissolved after the date of the will, and no child or children were born or adopted by the decedent after the date of the will. No state governmental agency of the state or charitable organization is named in the decedent's will as a devotee. The will names the decedent's son, Arthur Harrison, as independent executor to serve without bond. He is qualified, not disqualified, to serve as such and is entitled to receive letters of testamentary. A necessity does exist for the administration of this estate. Your Honor, this is a non-taxable estate. We ask that the appointment of appraisers be waived and that Arthur Harrison be appointed independent executor to serve without bond.
Thank you. After hearing testimony, the court finds that the will of Diamond K. Harrison constitutes a valid will. Further, the court finds that Arthur Harrison will serve as independent, was named in the will to serve as independent executor. The will is admitted to probate, and Arthur Harrison is appointed independent executor to serve without bond. And the court waives the necessity of appraisers. And
Thank-
you're welcome. I'm
Thank you
gonna
for having
sign.
us. Have a good
You're
day.
welcome. I'm gonna sign the order now
Okay,
and
thank you.
get there. Okay, I will sign it later, but thank you, Miss
Okay.
Clark, for your time.
Thank
And
you.
have a great, the rest of your morning.
Thank you, you too.
I call cause number 500-534, matter of independent administration for Christine Sarah Barker. Mr. Norris, are you ready to proceed, and were you sworn in earlier?
Yes, I'm ready, and yes, I was sworn in, Your Honor.
All right, thank you. You may proceed.
Thank you. This is for Christine Barker. Yes.
Yes.
All right, thank you. The will of Christine Sarah Barker was admitted to probate only as a muniment of title by this court on February 22nd, 2022. However, now a necessity exists for the administration. The decedent's will named Wayne Anthony Thompson to serve as executor. He has waived and renounced the appointment as executor, and that waiver is on file, as well as Sharon Woody Luzak was also named to serve, and she is also waived, and that waiver is on file. All of the distributees have consented to naming my client, Christy Lynn Barker, as independent executor, independent administrator with will and X to serve without bond. She is qualified, not disqualified. She's never been convicted of a felony, and it's a non-taxable estate, and we ask that you waive appraisers.
Thank you, Mr. Norris. This will was previously probated, and we are currently appointing Christy Lynn Barker to serve as independent administrator. I apologize, as an independent administrator to serve without bond, and the court waives the necessity of appraisers. And I will in the document. Thank you, Mr. Norris. And I believe you have other matters, so I'm not going to excuse you, but for the time being. I call number 509-821 in the matter of probate of will as muniment of title on Eileen Wright McCarthy.
I'm ready to proceed.
Thank you.
All right. Eileen Wright McCarthy, the decedent, died on February 2nd, 2022, and 4 years have not elapsed since the date of her death. At the time of her death, she was a resident and maintained a domicile here in Harris County. She left a valid will, which was dated April 5th, 2012, and that will was never revoked. No children were born to or adopted by the decedent after she made the will, nor was any marriage of the decedent ever dissolved after she made the will. No state governmental agency of the state nor charitable organizations named as a beneficiary in the will, and the decedent did not apply for nor did she receive Medicaid benefits on or after March 1st, 2005. To the best of my knowledge, there are no outstanding debts owing of the estate, except those that are secured by liens on real property. And as such, there's no necessity for administration. Your Honor, we ask that you admit the will as a muniment of title only.
Thank you. And the court takes judicial notice of the original will on file. After hearing testimony, the court finds the will of Eileen Wright McCarthy constitutes a valid will. There is no necessity for the administration of the estate. The court admits the will of Eileen Wright McCarthy dated April 5th, 2012 to probate as a monument of title only. Are you asking us to waive the affidavit for the fulfillment of terms as well? Or no?
That's, I can't remember on this one. I've got so
That's
many.
okay. We
Yeah.
won't waive it. We'll just leave it as is.
All right, thank you.
So thank you, Mr. Norris, for your time again. And I call cause number 510. Let me. Sorry, I did that out of order. Find this one. And I call cause number 510213 on application of probate of will as monument of title in the estate of In Chul Pang. And are you ready to proceed?
I am. I have witnesses for this one. I believe I see, I have both of my witnesses here. So I will call James Kwan.
Okay, and everybody was sworn in, correct?
Yes, they were here when,
Thank you. Okay.
all right, Mr. Kwan, can you hear me? Let me find him.
Sometimes
Mr.
you're
Kwan?
on.
I see him, but I don't know that he can hear us, maybe. Maybe we'll have to come back to this one. Sorry, Your Honor.
Not a problem. It happens. Is there another witness you have?
Oh, well, yeah, we can, I was gonna come back to this matter since I didn't want to
Sure.
split it up, yeah.
Okay, we'll go to cause number 510521. And the application of probate of will as monument of title on the estate of Janie Trevino.
Yes, Your Honor, I'm giving testimony for that one.
All right, you may proceed.
Thank you. Janie Trevino, the decedent, died on August 19, 2020, and 4 years have not elapsed since the date of her death. Decedent was a resident of and maintained a domicile in Harris County. She left a valid will dated November 14, 2006, and that will was never revoked. No children were born to or adopted by her after she made the will, nor was any marriage of hers ever dissolved after the will was made. No state or governmental agency of the state or charitable organizations named as a devotee in the will. She did not apply for nor did she receive Medicaid benefits on or after March 1st, 2005. According to the best of my knowledge, there are no unpaid debts owing of the estate other than those secured by liens on real property, and as such, there's no necessity for administration. We ask that you admit the will as a muniment of title only.
Thank you. After hearing the testimony, the court finds the will of Janie Trevino dated November 14th, 2006 constitutes a valid will. The court takes judicial notice of the original will on file. The court admits the will to probate as monument of title only. Find that. Thank you.
All right.
All right, I call cause number 510661 on application for independent administration in the estate of Walter Maurice Harris. Mr. Norris, you may proceed.
All right, thank you. I'll start with Mr. Longorio.
Yes, Mr. Norris.
Hi, thank you. Could you tell us your name, please?
Yes, it's Donovan Longoria.
All right, thank you. Your Honor, would you like me to show the will on the screen or?
Can you? I can stop
I can.
sharing. I can stop sharing. Thank you.
Sure. All right, Mr. Longoria. What, can you, how did you know the decedent at, Mr. Harris?
I've known him for, well, let me put it this way. The first time I worked with him when I was 16 years old. And so that's like 43 years ago, maybe. And I've known him probably 10 years before that in the congregation. We went to the same congregation that I've also worked for him several times.
All right, thank you. And over the years of knowing him, did you become well acquainted with his handwriting and signature?
I would say yes. It's been some time since I've seen it recently, but again, working with him, also in the congregation, documents were signed. And so, yes, I was able to witness his signature before.
All right, on the document here dated June 9th, 2020, which purports to be his last will, do you recognize that to be his signature?
Yes, it looks like his signature.
Right. And on the day that it was signed, would he have been at least 18 years of age and of sound mind?
Oh, yes, both.
All right, thank you. No further questions.
Thank you.
Now I'd like to call Miss Rebecca James. Hello, Miss James.
Yes, I'm here.
Oh, sorry, not Mr. Kwan. We'll come back to you in a minute. Sorry about
Oh,
that.
okay, okay, sorry. Yeah, I found the spot actually. Sorry. Yeah.
Thank you. Miss James, can you unmute?
Yes,
All right, thank you. Could you tell us your name, please?
Rebecca Harris James.
And how did you know the decedent, Mr. Harris?
He's my uncle.
And over the course of knowing him, did you become well acquainted and familiar with his handwriting and signature?
Yes, he lived next door to me when I was about 17 years old.
All right. And on this document here, which purports to be his last will that's dated June 9th, 2020, do you recognize that to be his signature?
Yes,
All right, thank you. And on the day that it was signed, would he have been at least 18 years of age and of sound mind?
yes.
All right, thank you. No further questions?
Thank you.
All right.
You're welcome.
Now, if I can find my, all right. Miss Petty, can you hear me?
Yes, I can hear you.
All right, thank you. Can you tell us your name, please?
My name is Cindy Harris Petty.
And how were you related to the decedent, Mr. Harris?
I was his oldest daughter or his oldest child.
All right,
Only-
thank you.
Only daughter.
Okay. And he passed away on September 7th, 2021. Is that right?
Yes, he did.
And obviously it's been less than 4 years since he passed away.
Yes,
And on the date of his death, he was a resident of and maintained a domicile here in Harris County.
yes, he did.
And on the document that we just showed to you, which purports to be his last will, do you recognize that to be his will?
Yes,
Did he ever revoke that will?
no.
Did he have any children or adopt any children after he made that will?
Oh, no,
Was he ever divorced?
no,
In the will, does it leave anything to the state of Texas, a governmental agency of the state, or a charitable organization?
no.
All right. And the will names, we're going to go through a list. We're going to, the will names Merle Harris and Maurice Harris, both to serve as independent executor, and they both waived and renounced that appointment. Is that correct?
That is correct.
And so you are next in line to be appointed as executor. Is that correct?
That is correct.
All right. And you are qualified and not disqualified. You've never been convicted of a felony. Is that correct?
No, no.
All right. And actually, I'm sorry, I misspoke. All of the distributees of the will have agreed to, have consented and agreed to have you appointed independent administrator with will annexed and to serve without bond. Is that right?
That is correct.
All right. Thank you. Your Honor, we ask that you admit the will and appoint my client as independent administrator with will annexed and to serve without bond and to waive appraisers as it's a non-taxable estate.
Thank you, Mr. Norris. The court takes judicial notice of the original will. As well, the court finds that after hearing testimony, the will of Walter Maurice Harris dated June 9th, 2020 constitutes a valid will. The will is admitted to probate, and Cindy Harris Petty is appointed independent administrator to serve without bond, and the court waives the necessity of appraiser. I'll sign that now. Thank you, Mr. Norris. Do you have anything else for this morning's docket?
I do. I have the one that we skipped over, Mr. Kang,
That is
Kang.
correct. Okay, and is everybody here now?
I believe so, Your Honor.
All right, let's go ahead and proceed with that, Mr. Norris.
Okay, thank you. Mr. Kwan, can you hear us now?
Yes, I can hear you better.
Thank you so much. All right, can you tell us your name, please?
My name is James Kwan.
And how did you know the decedent, Mr. Kang?
Yeah, Mr. King was, we go to same church. I'm the pastor.
All right, and I'm going to share my screen with you. Do you recognize this document to be his will?
Yes,
Okay, on this day, April 30th, 2018, I believe. Is this, did you sign this document in front of Mr. Kang?
yes, I did.
And on the day that you signed, were you at least 14 years of age?
Yes,
Was Mr. Kang at least 18 years of age and of sound mind?
yes.
And what was the other witness in Mr. Kang's presence and in your presence when he signed? Or in other words, did all of y'all sign this document at the same time?
I don't remember exactly.
All right. Do you remember that Mr. Kang, you signed it with him?
Yes.
Okay, thank you. No further questions.
Thank you.
All right. Mr. Kang, can you hear us?
Can you hear me?
Yes.
Okay, good.
All right, thank you. Could you tell us your name, please?
Sure. My name is Stanley Kang.
And how did you know the decedent, Mr. Kang?
He was my father.
All right. And he passed away on February 19th, 2022. Is that right?
It is correct.
And it's been less than 4 years since he passed away. Is that correct?
That's correct.
And on the date of his death, he was a resident of and maintained a domicile here in Harris County.
That's correct.
And that document, which was shown to us earlier, that was dated April 30th, 2018, do you recognize that to be his last will?
That's correct.
And did he ever revoke that will?
No, he did not.
Did he ever have any children or adopt any children after he made the will?
No.
Was he ever divorced after he made the will?
No.
Does the will leave anything to the state of Texas, a governmental agency of the state, or a charitable organization?
No.
Did your father ever apply for or receive Medicaid benefits on or after March 1st, 2005?
No, he did not.
And to the best of your knowledge, there's no unpaid debts of the estate other than those secured by a lien on real estate. And as such, there's no necessity for any kind of administration. Is that correct?
That is correct.
All right, thank you. Your Honor, we ask that you admit the will as a muniment of title only.
Thank you. The court further takes judicial notice of the original will on file. After hearing the testimony, the court finds that the will of Inchald Kang finds that the will dated April 30th, 2018 constitutes a valid will, and that there is no necessity for the administration of the estate. The court admits the will to probate as a monument of title only, and sign the will. And Mr. King, I'm really sorry for your loss of your father. Thank you for your time here today.
Thank you.
All right, Mr. Norris, is that it for you?
I believe that's everything, Your Honor.
Thank you for your time as well. You may be excused.
All right, thank you. Bye-bye.
Bye-bye. Okay. I call cause number 510326. An application of probate of will with letters testamentary in the estate of Crystal Lindsay Strain.
Good morning, Your Honor. Melissa Lovelace.
Hi, good morning. How are you?
I'm well, and yourself?
Very well, thank you.
Good.
And did your witness
He is
swear in?
with me, actually.
Hi, good morning.
Good morning.
And he was sworn in.
He was, yes, Your Honor.
Okay,
Mhm.
thank you. Okay, Miss Lovelace, you may proceed.
Okay, would you please state your name for the court?
William R. Strange II.
Okay, and you were married to Crystal Lindsay Strange, correct?
That's correct.
And she died on February 20th, 2022 in
Yeah.
Houston, Harris County.
Yes.
Okay, and she was 56 years of age.
Yes.
She resided specifically with you at 3205 Riverwood Park Drive, Houston, Harris County.
That's correct.
Okay, to your knowledge, did she pass without revoking her will, which was dated February 2nd, 2022?
No.
Okay. No, did she die without revoking it?
Oh, yes.
Okay, and you recognize the will, correct? Which is a copy, which is file stamped here.
Yes.
Okay, and Judge, we would ask that the court take judicial notice of the original will on file with the court.
Court takes judicial notice of the original will that is filed.
Thank you, Judge. Was there a child or any children born to or adopted by Ms. Strange after the execution of this will?
No.
At the time of the execution of the will, was she at least 18 years of age
Yes.
and of sound mind?
Yes.
Okay, and she did not have a marriage dissolved after the will was made, correct?
No.
Okay, and 4 years have not elapsed since the date of the application and the passing of Ms. Strange, correct?
Correct.
And the state of Texas is not a charity or devisee under her will, correct?
No.
Okay, and at the time of her passing, did she have property valued in excess of 150,000 in Harris County?
Yes.
And does the necessity exist for the administration of her estate?
Yes.
And does the will appoint you as independent executor?
Yes.
And there's no reason why you shouldn't serve. There's no felonies or anything like that.
No.
Okay. Judge, we'd ask that this is a non-taxable estate and that appraisers be waived and that the will be admitted to probate.
Thank you, Ms. Lovelace. After hearing testimony, the court finds that the will of Crystal Lindsay Strange dated February 2nd. Is that correct? 2022?
Yes, Judge.
Okay. Constitutes a valid will. Further, the court finds that William Robert Strange II was named in the will to serve as independent executor. The will is admitted to probate and William Robert Strange II is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. And I'll sign that now. Mr. Strange, I am so sorry for your loss.
Thank you.
Thank you for your time today. Ms. Lovelace, you may be excused.
Thank you, Judge. Take care.
Thank you. Have a good day.
Thank you. You too. Okay, I call cause number 510864. On application of probate of will with letters testamentary in the estate of Brandon Drew Warren. Mr. Bouillon, are you ready to proceed and has your witness been sworn in?
Yes, Your Honor, I'm ready to proceed. It's good to see you. I'm actually testifying for my client this morning.
Okay, wonderful. You may proceed.
Brandon Drew Warren, decedent, died on January 21st, 2022 in Tomball, Harris County, Texas at the age of 43. 4 years have not elapsed since the date of the decedent's death. He was a resident and owned property, personal and real, in excess of $100,000 in Harris County. His last will and testament that was left dated January 13th, 2022, was never revoked and is a valid will to my belief. A necessity exists for the administration of this estate. No children were born or adopted by the decedent after the execution of the will. The decedent was never divorced. There is no state or governmental agency or charitable organization named as a devisee in the will. Cherie Bozant Warren, or actually Cherie Warren, also known as Cherie Bozant Warren, is named independent executor in the will. She is not a convicted felon, and as such is qualified and not disqualified by law for accepting letters testamentary and is entitled to receive those letters. We ask that Her Honor admit the will to probate, taking judicial notice of the will, that Cherie Bozant Warren served without bond or other security. Upon taking the oath as required, that she's granted letters, independent letters testamentary, and appointed independent executor of Brandon Drew Warren's estate. No bond is needed, and it is not a taxable estate. I think I covered it all, Your Honor. I got all.
The court takes judicial notice of the original will on file. After hearing testimony, the court finds that the will of Brandon Drew Warren dated January 13th, 2022 constitutes a valid will. Further, the court finds that Cherie Bozant Warren, aka Cherie Warren, was named to serve as independent executor. The will is admitted to probate, and Cherie Warren is appointed independent executor to serve without bond, and the court waives the necessity of a procedure. I've signed it. Thank you, Mr. Bouillon. Have a great afternoon.
You too.
Thank you. The court calls cause number 510821 in the probate of will with letters testamentary for Rebecca Stewart Red. Ms. Beckries, are you ready?
Yes, we're ready. And my client, good morning. My client, Mr. Red, he should be here. I see him. Okay.
And Mr. Red was sworn in previously this morning.
Mr. Red, I don't think you were sworn in, were you?
No.
Okay, I can do that right now. If you could please raise your right hand. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed, Ms. Beckries.
Thank you. Mr. Red, would you please state your name for the court?
Richard Wallace Red, Jr.
And is it true that you are the brother of the decedent Rebecca Stewart Red?
Yes.
And is it true that she passed away on August 5th, 2022 in Houston, Harris County, Texas?
Yes.
At the time of her death, was she 85 years of age?
Yes.
And has it been less than 4 years since she passed away?
Yes.
And at the time of your sister's death, did she have a fixed place of residence in Harris County?
Yes.
And is it true that she passed away with a valid self-proved will that was dated March 25th, 1981?
Yes.
Your Honor, we ask that you take judicial notice. The original will is in the court's file.
Yes, the court takes judicial notice of the original will that's on file.
Thank you. Mr. Red, is there a necessity for administration of the estate?
I don't know.
Oh, yes, there is. We're asking there is a necessity for administration of the estate. And we're asking the court to appoint you as the executor for the estate administration. Did your sister ever revoke her will after she signed it?
No.
Is it true that there is no state governmental agency, charity, or any agency of the state named in the will?
No.
And then after the date of the will, did your sister have any children or adopt any children?
No.
after she signed the will, did she ever get married?
No,
And it's true that she was not married when she signed her will. Is that correct?
she was not. No, she's not married.
Okay. And is it true that the will names you, Richard Wallace Redd Jr., to serve as the independent executor without bond?
Yes.
And Mr. Redd, is there any reason why you should be disqualified to serve as the independent executor?
Repeat it.
There is no reason why you should be disqualified to serve as the executor,
No.
that you are qualified.
No.
Is that correct?
Yeah, I just didn't hear the no.
Yes. So you are qualified to
It's
serve.
already-
Is that correct?
Yes.
Your Honor, we ask that you appoint Richard Wallace Redd Jr. as the independent executor to serve without bond and admit the will to probate, and also waive appraisers.
Thank you. After hearing testimony, the court finds that the will of Rebecca Stewart Redd, dated March 25th, 1981, constitutes a valid will. Further, the court finds that Richard Wallace Redd Jr. was named in the will to serve as independent executor. The will is admitted to probate, and Richard Wallace Redd Jr. is appointed independent executor to serve without bond. The court waives the necessity of appraisers, and find that now. And thank you, Mr. Redd, for your time today, and I'm so sorry for your family's loss.
Thank you.
Okay.
Thank you, Your Honor.
You're welcome, Ms. Backries. You are excused, as well as your witnesses and clients.
Okay, thank you very much.
Have a good morning.
You too. Thank you.
I call cause number 510976 on application of probate of will with letters testamentary for on the estate of Stephen Michael Herbs. Ms. Dickey, are you ready to proceed, and has your client been sworn in?
Yes, Judge.
Oh, thank you so much. You may proceed.
Thank you. Mr. Herbs, please state your name for the record.
Marzell Stephen Herbs,
We are here probating the estate of Stephen Michael Herbs. What was your relationship to the decedent?
son.
Stephen Michael Herbs, the decedent, passed away on October 7th, 2022 at the age of 70 years, and 4 years have not elapsed since the date of his passing. Is that true?
Yes.
Is it true that the decedent had a fixed place of residence in Harris County, Texas at the time of his passing?
Yes.
Is it true that the decedent passed away with a will that was dated April 7th, 2022?
Yes.
Judge, we ask that the court take judicial notice that the court has the original will on file.
Yes, the court takes judicial notice of the original will that is on file.
Thank you, Judge. Mr. Herbs, the will was self-proven to the best of your knowledge. Is that true?
Yes.
To the best of your knowledge, the will was never revoked or modified by the decedent. Is that true?
Yes.
Is it true the will named yourself, Marzell Stephen Herbs, to serve as independent executor, to act independently and without bond?
Yes.
Is it true that no state governmental agency of the state nor charitable organization is named by the will as a devisee?
Yes.
Is it true that after the date of the will, no child was born to or adopted by the decedent?
Yes.
Is it true that no marriage of the decedent was ever dissolved after the will was made?
Yes.
Is it true that a necessity exists for the administration of this estate?
Yes.
Is it true that you are not disqualified by law and you are entitled to receive letters testamentary?
Yes.
Are you requesting for the court to appoint you independent executor over the estate and for the will to be probated and for appraisers to be waived?
Yes.
No further questions, Judge?
Thank you, Ms. Dickey. After hearing testimony, the court finds that the will of Stephen Michael Herbs dated April 7th, 2022 constitutes a valid will. Further, the court finds that Marzell Stephen Herbs was named in the will to serve as independent executor. The will is admitted to probate, and Marzell Stephen Herbs is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. And Mr. Herbs, I'm so sorry for the loss of your father. Thank you for your time here today.
Thank you, Your Honor.
You're welcome. And Mrs. Dickey, I'm signing the order and thank you as well. Have a good rest of your morning. You are excused.
Thank you, Judge. You as well.
Thank you.
Thanks.
I call cause number 510747 on application of probate of will with letters of testamentary in the estate of Elisa or Lisi Evie.
Yes, Your Honor, I'm ready. And I'm going to provide the testimony, and I was sworn in earlier.
Mr. Frazier. Okay, wonderful. You may proceed.
My name is Kyle Frazier. I was well acquainted with Elise H. Peavy. She was a client of mine. I prepared her last will and testament. Elise died on October 30th, 2022 in Harris County, Texas at the age of 86 years. 4 years have not elapsed since the date of her death. She was domiciled and had a fixed place of residence in Harris County on the date of her death. Can I ask the court to take judicial notice that you have the original will on file?
Yes, the court takes judicial notice of the original will on file.
Okay, and that will dated July 30th, 2019 was never revoked, so far as I know. There is a necessity for administration of the estate. There were no children born to or adopted by her after the date of the will, and there was no marriage dissolved after the date of the will. In the will, she named her two daughters, Valerie Peavy Meek and Pamela Peavy Pierce, who also goes by Pamela Elise Pierce. She named her two daughters to serve together as independent co-executors without bond. They're each qualified to serve. Neither of them is disqualified for any reason. And they're entitled to letters. It's not a taxable estate. We'd ask that you waive the appointment of appraisers.
Thank you. After hearing the testimony, the court finds the will of Elise H. Peavy dated July 30th, 2019 constitutes a valid will. Further, the court finds that Valerie Peavy Meek and Pamela Elise Pierce, aka Pamela Peavy Pierce, were named in the will to serve as independent co-executors. The will is admitted to probate, and Valerie Peavy Meek and Pamela Elise Pierce are appointed as independent co-executors to serve without bond, and the court waives the necessity of appraisers. Sign that right now. Thank you, Mr. Fraser. You are excused. Thank you.
Thank you.
Have a good day.
You too.
I call cause number 510778 on matters of probate of will with letters of testamentary in the estate of Janice K. Passenger. Mr. Beard, are you ready to proceed?
I'm ready, Judge. Good morning. I will be testifying. I have been sworn in already.
Thank you.
My name is John Wayne Beard. I represent Larry Kenneth Passenger, who's the applicant in this case. The decedent, Janice K. Passenger, died October 22nd, 2022 in Harris County, Texas, at the age of 75 years. 4 years have not elapsed since her death. The decedent was domiciled in and had a fixed place of residence in Harris County, Texas at the time of her death. I'm familiar with her will, having prepared it, and testifying that the will that was filed with this court dated November 26, 2017 was the original will of the decedent, and ask the court to take notice that it is in possession of the court.
The court takes judicial notice of the original will.
There is a need for the administration of this estate. The will was self-proved. The will was never revoked. No state, government agency, or charitable organization is named in the will as a devotee. After the will was made, no child was born to or adopted by the decedent. After the will was made, no marriage of the decedent was ever dissolved, nor was the decedent married after the making of the will. The will names Larry Passenger to serve as independent executor without bond, and there's nothing by law that would disqualify from Mr. Passenger serving in that capacity. We're asking the court to admit the will of the decedent into probate, to appoint Larry Passenger as the independent executor to serve without bond. Judge, this is a non-taxable estate. We're asking the court waive the necessity of appraisers.
Thank you, Mr. Beard. Excuse me, Mr. Beard. After hearing testimony, the court finds that the will of Janice K. Hassinger dated November 20th, 2017 constitutes a valid will. Further, the court finds that Larry Kenneth Hassinger was named in the will to serve as independent executor. The will is admitted to probate, and Larry Kenneth Hassinger is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. I'll sign that, Mr. Beard, and thank you so much. You are
Thank you,
excused.
Judge.
You're welcome. I call cause number 508-831. On application of probate of will as monument of title in the estate of Anika L. Perry. Mr. Swait, are you ready to proceed? And has your witness been sworn in?
No, ma'am, Your Honor.
All right, I can do that right now. If you could raise your right hand. Do you solemnly swear that the testimony you will give in this case to be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you. You may proceed.
Please state your name for the record.
Larry Jean Perry,
Where do you live?
11461 Sabo Road, Houston, Texas.
Who was Ancita L. Perry?
That was my wife.
Were you ever doing, well, she was never divorced, is that true?
That's true.
On what date did she die?
July 15th, 2022.
Has she been a resident of Harris County?
Yes.
How long?
Probably 50 years.
Okay. Now I'm going to show you a copy of the will. The original will has been filed with the court, and asked the court to take judicial notice of the original will.
The court takes judicial notice of the original will on file.
Did Ms. Perry ever revoke the will to your knowledge?
No, she did not.
Are there any codicils or additions to this will to your knowledge?
No.
Are you aware of any instrument revoking the will?
No.
To the best of your knowledge, you believe the will was validly executed?
Yes.
Was she of sound mind when she died?
Yes.
No contest will has been filed?
No.
And you're named the executor of the will?
Yes.
And you have personal knowledge, full knowledge of financial affairs of Ms. Perry?
Yes.
Are there any debts owed by the estate?
No.
Is there a necessity for administration of the estate?
No.
After the will was signed, were there any children born or adopted by Ms. Perry?
No.
Now we'll reduce your testimony and proof of death, and we'll file that with the court after the hearing. Are you asking the judge to sign this order in the will to probate as a monument of title?
Yes.
We respectfully request that continue as proper, finding that the proceedings will commence within 4 years of her death, determining Ms. Perry was a resident of Harris County, Texas, that the will was self-proved in a manner prescribed by law, that there are no debts owned by Ms. Perry which are not secured by liens upon real estate, and that there's no necessity for administration of the estate, and the will be admitted to probate as a monument of title, and grant any other relief as may be proper.
Thank you, Mr. Swait. After hearing testimony, the court finds, and I'm sorry, Mr. Perry, how do you pronounce your wife's first name?
Anissa.
Anissa. After hearing testimony, court finds that the will of Anissa Perry dated October 13, 2005 constitutes a valid will, and that there is no necessity for the administration of the estate. The court admits the will to probate as a monument of title. And I'll sign that now. Mr. Perry, I'm so sorry for the loss of your wife. And thank you so much for your time here today.
Thank you, Judge.
You're welcome.
Thank you, Your Honor.
Thank you. I've signed it. Mr. Swait, you are excused. Thank you.
Thank you very much.
I call cause number 511-568 in the estate of Bertha Fierro in the probate of will with letters testamentary. Ms. Perry.
Have Mr. Massis and Ms. Patterson, and I believe they were both sworn in. Mr. Massis would have to let us know if he has not.
I was sworn in this morning, yes.
Wonderful. Thank you. You may proceed, Ms. Perry.
Mr. Massis, would you please state your full name for the court?
Sure, Ramon Massis.
Massis, I apologize.
Okay.
Were you present on May 13th, 2008, when Bertha Therios signed her last will and testament?
That's correct.
And did you serve as a subscribing witness on that will?
That's correct.
And you have seen a file stamped copy of the will that I sent to you that is on file with the court. Do you recognize that file stamped copy of the last will and testament dated May 13th, 2008 to be Bertha Therios' last will and testament?
Yes, I do.
And do you recognize her signature and your own on that document?
I do.
Did Ms. Therios sign that document in your presence and in the presence of Stephen Fodry?
Correct.
And did she declare that to be her last will and testament?
Yes.
And did you and Stephen each also sign the will in Ms. Therios' presence as witnesses?
Yes.
On May 13th, 2008, to the best of your knowledge, was Bertha Therio of sound mind and at least 18 years of age?
Yes.
And to the best of your knowledge, on that date, were you and Stephen Fodry each above the age of 14?
Correct, yes.
I'll pass the witness and call Ms. Patterson. If you would please state your full name for the court.
Joan Schroeder Patterson.
And did your aunt Bertha Therio die on April 3rd, 2022 in Harris County, Texas?
Yes.
And your aunt was 79 years old and a resident of Harris County, Texas at and before her death, correct?
Yes.
And you have also seen the file stamped copy of the will, which you have filed with the court, and that is your aunt's last will and testament, correct?
Yes.
And to the best of your knowledge, did your aunt die without revoking this will?
Yes.
And at the time of execution, was your aunt of sound mind and at least 18 years of age?
Yes.
There were no children born to or adopted by your aunt after execution of the will, correct?
Correct.
And your aunt did not have a marriage dissolved after the will was made. Is that also correct?
Yes.
4 years have not elapsed since her date of death and the time when our application to probate was filed, correct?
Correct.
There are no charities, states, or governmental entities named as a beneficiary under this will. Is that also correct?
Correct.
Does a necessity exist for the administration of your aunt's estate?
Yes.
And does the will appoint you to serve as the independent executor without bond?
Yes, ma'am.
And lastly, are you qualified and not disqualified from serving as executor?
Yes.
Nothing further, Your Honor. I ask that you would take judicial notice that the original will is on file and that the will be admitted to probate and that my client be appointed as the independent executor without bond and that appraisers be waived.
Thank you. The court takes judicial notice of the original will on file. After hearing testimony, the court finds that the will of Bertha Therio constitutes a valid will. Further, the court finds that Joan Schroeder Patterson was named in the will to serve as independent executor. The will is admitted to probate and Joan Schroeder Patterson is appointed independent executor to serve without bond, and the court waives the necessity of appraisers. And I'll sign the order. Ms. Patterson, I'm sorry for your family's loss. Thank you for your time here today as well, Mr. Massis.
Thank you.
You're welcome. Thank you, Ms. Perry. You're excused.
Ask if everybody's free to leave.
You're excused.
Thank you, ma'am.
Have a good day.